So thank you very much for being part of this webinar. This is on key considerations for business that are hiring. So full life cycle of an employee relationship with their employer. And it's an absolute pleasure to have Joe Nisbet and also Andrew Maxwell from Harper MacLeod. I'm going to hand over to Andrew to take us through a few things. Thanks.
Thanks, Jamie. Let me just share my screen. Can everyone see that okay?
Yeah, absolutely.
Perfect. So I guess what I'm kind of going to go through is various different key considerations which employers should have when starting the employment relationship primarily. And the sort of title of the presentation is employment status. And employment status is often the first thing that employers will need to consider when engaging individuals to work with them. So what I'll do is I'll start off by just looking at employment status generally. Why does it matter what status you choose? Then I'll look at some of the kind of key categories of relationships that you can have. So whether that be employees, workers, 0-hour workers or casual staff. And I'll also touch upon some considerations around engaging people as self-employed contractors, because that's also an option which is available. I'll then look at sort of key rights. So for all the different types of status, what rights do those individuals have? Because it does vary from category to category. And then I'll have some guides and styles to kind of talk through what sort of things we'd have to do when engaging those individuals. And then we'll have some brief discussion on steps around managing that relationship. I think certainly in terms of managing the relationship, a lot, and part of the reason why I'll kind of go on at length around employment status is that in terms of managing the relationship, as with a lot of things, you set the table for this in terms of how you initially engage people. So in terms of how you manage that relationship, what relationship you've chosen to enter into, or what relationship you do have with an individual, that will kind of inform how you manage that going forward. So just looking at employment status and why it matters. So employment status governs the rights and obligations of employers and individuals. So depending on what status you have, you will have different relationships with people, and those individuals will have different rights, and there'll be different obligations that you will have towards those individuals. So I've kind of categorized the first three. So the kind of main ones, which is the genuinely self-employed. So those people have very few implied rights. They don't have many rights in terms of the employment legislation. However, there are rights that will arise from the agreements that you will have in place with them. Then you'll have the employee, which is the gold standard in terms of employment rights. They'll have lots of different rights in relation to the statutory obligations that you'll have towards them from the Employment Rights Act and other pieces of legislation, as well as those which will be contained within the employment contract. And then you have worker status. So worker status is distinct from employee, be slightly below that. They will have fewer rights than employees, but they will still have some important protections which they share with employees, and important ones such as discrimination. Aside from, I suppose, employment rights, there will be, status does matter as it relates to matters of administration of tax and national insurance as well. That's not something which I'll be able to advise or kind of talk about in any great depth today. However, it is worth another sort of point in terms of consideration that there will be employment status for the purpose of employment rights, and then there's also status in relation to tax and national insurance as well. So in terms of employment status and why it matters, you can agree with an individual what relationship that you want to have with them. However, ultimately, if there turns out that there is a dispute about that relationship, then employment tribunals and HMRC can look behind the contracts to determine the real nature of the relationship. So they look at, there's various tests which they look at in order to determine, is this an employment relationship? Is this a self-employed relationship? Is this a worker relationship? Now, there's no definitive definitions, so there's nothing within the legislation which says, this person is a worker, this is an employee, this is self-employed. The tests have developed through case law, and they create a series of what we call key indicators, which point to what the correct status is. So I suppose famously over the last number of years, you might have seen in the news cases around the Uber drivers. So that was obviously a new kind of disruptive platform. These individuals, they had a relationship with Uber, and what the courts were tasked with deciding is what type of relationship that was. Were they employees? Were they self-employed, as Uber claimed, or were they workers? And that'll be a judgment call by employment tribunals or other courts and HMRC as to what relationship the person is. So the tests are similar, but they can often lead to different outcomes. So you will have, what that means is you'll have different situations where someone can be viewed as an employee or a worker for employment rights, and then self-employed for tax reasons, or vice versa. So there are, in terms of what I was saying about the different statuses and why it's important for employment rights as well as taxation, there will be different tests for employment rights as it would be HMRC. So you can have some individuals who will be have sort of dual status. They'll have one status for employment rights and another for HMRC, and that just happens in relation to the way the tests are slightly different. And I've pointed out there is the HMRC employment status indicator tool. So for HMRC's purposes, so for tax purposes, there is a tool that's available free online, HMRC use, and that can be helpful for determining someone's employment status for tax purposes. You input information and it would give you a kind of result of what that is. Now that it's not necessarily binding, but it can be useful if HMRC eventually do look into a particular arrangement and to determine what status a person truly has. So I think the reason that we kind of go on about status is that it's important that we encourage employers to put in place the appropriate contractual relationship at the outset, and that they use contracts to sort of regulate and record the relationship. And it's not about necessarily about just protecting employers from protecting them from disputes if disputes arise, but having a contract in place and having the right contract in place will ensure that everyone knows their rights and responsibilities in relation to that working relationship. So who has what obligations in terms of things like pay, hours of work, what work is done, all those sorts of things. I think the worst thing that a kind of company could do is not to properly document the relationship in place, because then it might not be clear to either party who's responsible for important features of the relationship. I think everyone should gain by taking the time to ensure that appropriate documentation is implemented and exists, setting out key aspects of the relationship at the outset of that relationship. And I think this was one point which I'll kind of come on to, is that it's important that sometimes, as I say, that the contractual documentation can say one thing, and often what we have is people who will use template documents, and they'll use an employment contract document, or they'll use a contractor document and say that this person is self-employed. But when you actually look at the relationship and how it operates in practice, then it's an employee-employer relationship, or it's a worker-employer relationship rather than someone that's genuinely self-employed. So I think when creating the documents at the outset, it is not just what kind of parties want the relationship to be in terms of what status they've chosen. It's actually thinking about how the relationship will work in practice, and making sure that the contractual documentation is set up for that appropriate relationship. So looking first at the genuinely self-employed person. So if you're a genuinely self-employed person, you're an individual that has a contract whereby they undertake to do or perform personally any work or services for another party to the contract, whose status is, by virtue of that contract, that of a client or customer of any profession or business undertaking carried on by that individual, then that individual will not be an employee or a worker, but will be a genuinely self-employed independent contractor. So someone who's genuinely self-employed is responsible for making their own decisions in performing the job. So by way of contrast, an employee subject to the directions of an employer and how they would carry out a task. Someone that's genuinely self-employed would have responsibility for how they carry out that particular task. Economically, someone that is genuinely self-employed would stand on their own 2 feet, they're in business of their own accord. I guess the risk is that, if parties treat an individual as a self-employed contractor, but the contract and working arrangements don't bear this out, then when an employer ends a relationship, then there can be risks in relation to employment claims. So hence the reason why it's important to make that relationship clear and make sure you've got the right relationship at the outset. And there's also, as I say, there's issues there in relation to HMRC potentially making claims if someone's not genuinely self-employed in relation to unpaid deductions for tax and national insurance contributions and potentially compliance with national minimum wage. Those who are genuinely self-employed have the least protection and statutory entitlements. So they still have some protections under law for things like health and safety, and in some cases protection against discrimination. However, in general, their rights and responsibilities are only set out by the terms of the contract which they have with the company, and nothing else. So in terms of the key indicators of someone that's genuinely self-employed, I suppose the key indicators are that it's not an employment relationship. It doesn't look like an employment relationship. So, for example, the invoice for the work that they carry out, they're not paid a monthly salary, or they're not paid a wage each month. They're paid gross, so there's no tax deducted from that. They are registered with HMRC, self-employed, so they would pay their own taxes and national insurance. They would often have their own business or professional indemnity insurance for the work they're doing, so they're insured and they basically do work on their own behalf. In terms of they agree their schedule, so they're not told or dictated to by anyone. So this is sometimes which can kind of come into conflict in this. And I suppose what I mean by this is, there may be a schedule for them to do a particular piece of work for a company, so they will be tasked. They're brought in to do a particular bit of work, and there may be a deadline for completion of that work. But in terms of the timescale for that, you might have kind of key milestones. There's a particularly big task, but in terms of their own schedule, they're not in the office 9 till 5, day in, day out. They have the freedom, because they're in business of their own accord. They kind of come and go as they please and do the work when they please, provided it comes to the deadlines. So sort of further key indicators is that the person isn't treated like an employee, so they don't have probationary periods, they don't have performance reviews, there is not a disciplinary process that they'd be subjected to. They also don't qualify for things like sick pay or holiday pay or pension, and they're not allowed to do anything that's not expressly agreed with the company. I guess other kind of aspects which were not on the slides would be that they have they don't get paid expenses, so they're in business of their own accord. So you have the contractually agreed rate for a piece of work, but there's no expenses as part of that. Whatever expenses they incurred in relation to equipment or transportation, that's something which they run up at their own expense. They also would have one of the kind of key points in the case law is around a right of substitution. So you're engaging a self-employed contractor, so they can appoint a substitute to perform work, if they're unavailable for whatever reason. Other aspects is that they would carry financial risk. So they if the project runs over, they don't get paid anymore. They get paid the set price that's agreed in the contract. So they're running a business on their own accord, so that they kind of carry the risk that anyone running a business would have in that, without the kind of benefits of employment rights. So the next one is obviously just that of employee status. So employees attract the most protection, and we kind of call it the gold standard of all status. And they have the most protection, the most rights. And basically to be an employee, and in contrasting this from those that are genuinely self-employed, there's a 3-part test which they have to satisfy, and that's kind of been borne out from the case law and the Uber case and things like that. So the first of the tests is what they call personal service. So they must personally perform the work for the company. So there's no fettered or unfettered right to send a substitute to carry out work on behalf. And now anyone that's been an employee would know that's obviously kind of self-explanatory. You wouldn't be employed and say, don't fancy coming into work today, I'll send someone else to do the work for on my behalf. You are personally employed to do a work with a contract of employment. So again, contrasting that with those that are self-employed, self-employed people can appoint a substitute or have someone that works for them to do the work. If you're an employee, you would be performing the work personally. The second test there is what we call mutuality of obligation. So what that means is there has to be obligations on both parties. So the employer is obliged contractually to provide the individual with work, and the individual is contractually obliged to do that work. So there's that's what they call the mutuality of obligation. Employer has an obligation to give them work. Employees are contractually obliged to do the work that they're contracted to do. So that was one of the kind of the key parts in relation to the Uber cases, was whether people were mutually, Uber didn't have that mutuality of obligation. There was no obligation for Uber to give the drivers work. So the drivers obviously arguing they were employees, but the way the Uber platform worked, there was no obligation for Uber to provide work for the drivers. It was the drivers could accept or decline that work if they so wished. The final element is this idea of control. So an employer has to have a degree of control over the manner the way the work is carried out. So again, contrasting with the self-employed, those are genuinely self-employed. Someone that's genuinely self-employed, you may employ them to do a particular piece of work. We don't have any control over how that work is completed. How they do that is up to them as the self-employed contractor. You kind of contrast that with an employee. With an employee, you'll have a level of control over how they carry out work. You'll be basically directing them, this is the task, this is how you're going to do the task. Again, looking at how this sort of applied in the Uber case, with the Uber case, there was the issue in relation to route selection, where again, so what eventually happened is they were given worker status, not employee status, but it was the control that Uber had over the drivers that, in terms of route selection, the drivers didn't have the ability to just drive whatever route they wanted to. The app created the route for them, the drivers drove that route, and if they didn't, they had to basically ask the customer, or they'd be penalised for deviating from the select route that Uber had. So that's that kind of level of control. I think what you can see with these ones in terms of mutuality of obligation and control is, in the Uber case, there was some of it which would suggest that it was employees, and some of some were in favour of Uber. Some of it, particularly the control element, was in favour of the drivers in terms of what they were arguing for, which is kind of why they had this middle ground of worker status, that was eventually kind of agreed upon. So they're the 3 tests, and if the answer to all those 3 tests is that there is no, it has to be personal service, there is mutuality of obligation, there is control, then it would be that they are an employee. If they're not any of these, then it's a self-employed, and the worker status sort of largely kind of ends up somewhere in the middle. So yeah, in terms of the worker, under the Employment Rights Act, a worker is defined as an individual who's entered into work or worked under a contract of employment, or any other contract where an individual undertakes to perform work personally being the keyword. So there's no right of substitution. Any work or services for another party to the contract whose status is not, by virtue of the contract, that of a client or customer of any profession or business undertaking carried out by the individual. So I guess the worker is where it can get tricky. personal relationship, I think, is quite key, and that was part of it with the Uber cases, where they were personally, the Uber drivers couldn't just get a substitute to do the driving for them. They were the ones that were personally driving when they were logged onto the app. So personal status is something which would kind of strongly indicate worker status, but it's this kind of in between of an employee or worker, and when you have disputes with this, you'll often get people that will be arguing quite strongly that they're employees because they get additional protection, and then the companies would prefer worker status because there isn't the same level of protection. Workers do have some protection, but not the same level that they would as if they were an employee. So now we kind of know what the different statuses are. I guess it's advising on what is the right status. So I mean, I guess the right status is the status is correct for the company in question. So there's not a kind of a one answer, one size fits all. And every working relationship has its own status as well, and it is determining between the individual and the company what is the right status for them. And it's not just simply that you agree that an individual work for you and then calling that relationship either an employed relationship or self-employed. It's the detail of the agreement that's in place which is important, and ultimately what happens in practice is going to be important as well. I guess that you should remember that the different status points will guide you in terms of what status is right, and ultimately employers can influence the status of a relationship by carrying out how different aspects of the relationship is carried out over time. So in terms of what level of if you want a self-employed relationship, you have to give up that level of control. If you're trying to exert too much control, that might indicate that it becomes an employed relationship. So it's having being mindful of you agree something at the outset and what it is, but continuing to audit that relationship to work out has it changed? Are we doing something which is fundamentally changed that relationship? So I mean, I think there, as I say, that's the kind of the key parts for the different statuses, and establishing which one is which. Now just kind of coming to the issue of rights between them. Yeah. Sorry, actually, I'll just go back. So in terms of key tips for the relationship, again, just reminding that tax status is not the same as employment right status. So I've mentioned the HMRC indicator before. So you could have a situation where someone's got different status for both. So just being mindful of that. Documents are a great starting place in terms of documenting the relationship. It's essential to have the relationship documented. Make sure you have the right documentation in place at the outset. Ensuring that the documents are signed and retained. Basic thing, but people often forget. They'll issue documents, won't have them signed by the individual. Having that, is half the battle. Having hard copies and electronic copies of the documents available, so in case documents are lost. And then just again, reminder: no one size fits all. So just because you have some people as employees and some people, doesn't mean that everyone should be an employee. And again, if you have some individuals engaged as self-employed, remembering that not just everyone's self-employed. It will depend on the individual relationships between the two. I guess, points I've touched upon, but status can change through time, but it's usually only when it goes wrong that it gets tested. So what I mean by that is status can change over time. So as I said, you have to constantly audit the relationship. Has it changed? Was it self-employed and now it's an employed relationship? But it's only usually in circumstances where perhaps people fall out, or if there's perhaps a tax assessment that the status could be challenged. So you could be working quite happily with an individual, things could be fine, and then you could fall out with them. They're engaged in a self-employed contract, you fall out with them, the relationship's terminated. Then at that point they bring a claim for I was employed. I was unfairly dismissed. I've got claims for holiday pay, sick pay, all these sorts of things. So, whilst that's likely to happen, it won't get it's unlikely to get challenged during the relationship, usually at the end. That's why you kind of don't want to leave yourself in a position where it's only at the end of the relationship you're kind of finding this out, that there's perhaps a risk that they were an employee. If you constantly look at things, constantly audit things, then that's unlikely to happen. And when I talk about liabilities there, the liabilities can accrue for years and years. So in relationships, we're looking at those two examples, national minimum wage or holiday pay. If someone's been paid under the national minimum wage and they were a worker or an employee, then the liability can stretch back to the start of the relationship. Again, same with something like holidays. If they were to be viewed as an employee or a worker and have the right to receive holiday pay, but they were paid as self-employed, that would go back for the length of the relationship. So again, it's just being clear to constantly review these things, because the worst thing you could have is if someone's engaged as self-employed for 3 or 4 years, then they leave in a bit of a cloud, there's a dispute, and then suddenly they're asking for liability for years and years of holiday pay. So that's the kind of, again, by having that properly documented at the start, making sure that you try to appraise the relationship, has it changed, has it not, and then you can make sure that there aren't kind of any unwanted surprises come the end of the relationship. There's a kind of table which is going to run over a couple of different slides here about key rights identified. So these will focus on the employee and worker relation statuses and the kind of the rights they have. So I'll kind of flick through the slides just so you kind of get an idea of them. But I think the kind of important thing to note is that an employee has, the rights that an employee has, the rights that a worker has, an employee has all of those rights. So because the employee's gold state, the gold status, any right that a worker has, an employee will also have. So kind of what you're focusing on is the kind of the differences and what additional rights that an employee would have that a worker doesn't have. So in terms of the rights that an employee would have that a worker doesn't have, they have the right to receive things like statutory sick pay. They have the right for paid leave in relation to things like maternity leave, paternity leave, adoption leave, shared parental leave. They also have rights in relation to unpaid leave for caring for dependents. So there's a right to have leave if a child is sick. They have the right for unpaid leave. They also have the right to request things like flexible working. That's only an employee or a worker doesn't have that right. They also have rights in relation to trade union membership. They have rights under what we call to pay. So if they're transferring to another company or transferring into one company, they have rights in relation to that. They have rights in relation to statutory minimum notice periods. So if you are terminating an employee's contract, they have to be given the minimum statutory notice, which is a week for every complete year service up to a maximum of 12. They have protections from unfair dismissal. They have rights to a statutory redundancy payment. They have rights if an employer is insolvent as well. As I said, the rights that workers have, employees have all of these rights as well. So, the workers' rights there has been a kind of shift, I think, as we've kind of transitioned over the last couple of years with what they call the gig economy, and a lot of the kind of these new apps and things like that have kind of transformed the world of work. You've seen that workers have, as a result, have gained more rights, and there's potentially probably more rights which might need come in. There's been talk of an employment bill since 2017, but just I think the government has been, Brexit and pandemic, it's never actually come to fruition. So there's potentially for more rights to come in place. But certainly workers have been given and employees have been given new rights recently. For example, there's rights to have itemised pay slips, right to be given a written statement of particulars, which I'll come on to explain in a bit more detail. They've both the workers and have got rights in relation not to receive deductions from wages. They've both got the right to receive the national minimum wage. They've got the rights to receive holiday pay. They've got rights to be auto-enrolled into a pension. They've both got rights not to be discriminated against. So there's kind of common rights between both of them as well. So those last couple of slides is a table of the kind of different key rights that they both have. As I mentioned there is the written statement of terms. So there's always been a requirement to have what's known as a written statement of terms issued to employees and workers. However, the information which is being included in that is ever increasing. So previously it was very basic information which had to be included in this, and now there's kind of ever more information that has to be done. So the written statement of terms, these are certain minimum standards that have to be given to employees within a certain period of them starting their employment as either an employee or a worker with a company. So they have to be given this as part of a kind of central document. So you don't necessarily always have to call this a contract of employment, although often employers will include it as part of their contract. But this can sometimes be slightly less than a contract, so that's why it's called the written statement of terms. So there's certain key information. I've included some of it on the slide here. So, for example, the job title, a description of the work, when the employee or when the worker started with the company, how much and how often the employee or worker will get paid. So, what's their salary? They have an hourly rate. They have a weekly rate. How often do they get paid? Do they get paid every week? Do they get paid every month? Do they get paid every 4 weeks? When do they get paid? Is it the last day of the month? Those sorts of information. Hours of and days of work, and also holiday entitlement. So what days are they expected to work on? Is it just Monday to Friday? Do they have to work at weekends potentially? Hours, is it just 9 to 5? Would there be hours outside of that? Is it a shift pattern? Night shifts? When would they be working? Holiday entitlement, what holidays do they get? Do they get the statutory minimum? Do they get bank holidays included? Are they expected to take bank holidays off, or are they additional days that carry over? Location of work, so where are they expected to work? Often we've got quite a lot of people at the moment with this, with hybrid working. Are they expected to work in the office, expected to work at home? Is it a combination of the two? Probationary period, are they subject to a probationary period or not? What are the conditions of that? Is it just a period of 6 months, 3 months? Any conditions for passing probation? Some of the newer ones relate to other benefits. So, is it just pay and salary they get? Are they going to get bonuses? Do they get health insurance? Do they get private health care? Death and service benefit? What benefit? Other benefits do they get from the employer? Obligatory training. So, is there training that has to be given? Who pays for the training? Does it, if there's obligatory training, does the employer pay for that, or does the employee have to meet that out of their own expense? So there are certain things which have to be in a contract of employment or a written statement of terms just to comply with the statutory obligations. I guess when we look at contracts of employment, there are other aspects which we will advise clients on, about things they might want to include in an employment contract. So, for example, we have confidentiality provisions. Particularly with new businesses, there'll be a lot of confidential information that you potentially want to protect. So making sure you have strong, confidentiality clauses just prevents and helps to ensure the safety of that information. Again, restrictive covenants. So again, with kind of new businesses and startups and things, preventing people from going to work for competitors. Preventing people going to work for a competitor for a period of time. Preventing people to go to a competitor and poaching clients or poaching key staff members, or dealing with clients or dealing with staff members, those sorts of things, just to protect the commercial interests of the business. And kind of similar again with intellectual property. Intellectual properties can be a key thing as well within a new business. Making sure that you protect any intellectual property that is you create. But also, if the employee creates it, that the rights for that are assigned to your company. It's not something they can take with them. The kind of final part is, I suppose, employment claims and how to avoid them. This kind of idea of how to manage the relationship. So as I kind of went through the different employee rights and worker rights that have, you'll see there can be claims for all manner of them, but I guess the kind of common claims that we see most frequently are claims around unfair dismissal. So if the employment relationship has been terminated, has it been terminated properly? Has the employee been treated fairly? Discrimination claims, so people complaining that they've been treated less favourably because of one of the protected characteristics. So whether it be their gender, disability, race, religion, all manner of different things. And then unpaid wages, there can often be unpaid wage, disputes in relation to issues with calculation of wages, how much someone's due to get paid, particularly around bonus schemes and things like that. So I guess in terms of steps to avoid claims, there's an element, and I often say this to clients, where claims are often unavoidable, and having to defend a claim is often what I would call is the cost of doing business. So I've had a case recently which we've managed to resolve successfully for the client, where the client hadn't done anything wrong. There was no merit to any of the claims that had been pursued by the employee, but they had to basically defend the action. So they had to instruct lawyers to defend the claim. But I guess in terms of part of the reason why we've been able to defend it successfully is due to the steps that they've taken, whilst employing the individual to make sure that there was no merit to the claims that they brought. So some of the kind of key points which I kind of identified were having clear and well communicated policies, and I suppose that relates to contracts as well. So if you have a disciplinary policy, for example, making sure that's clearly set out, what are the rules, what are the code of conduct, what's expected of an employee when they work with the company, what standard of behaviour, and making sure that's well communicated, that that's accessible. It's sent out to employees as part of an intranet. It's sent to them when they start with the company. It's something that's easily accessible. Other policies, for example, equal opportunities policy, making sure that all staff members are treated equally and there's respect, dignity at work, all these sorts of things. Having all those things in place can make sure that an employee then doesn't come and say, well, I was never told this, or when they behave badly, or that for some reason they've been persecuted because of their gender, for example. That's all set out there. I guess on that, there's also treating employees consistently. So making sure that if there's one situation, and you do one thing, is then you're setting yourself a precedent, and that you don't deviate from that in another situation. So again, in the case I had recently, that was one of the key complaints, was that they've been treated differently from other people because of their race. So they were saying, well, such this was happened, and this happened to me, and that's because of this. And that wasn't the case, and they were able to show that they were treated the same as other employees had been in the past, and there was precedent, so that there was just no legs to it. They may not have been happy with the treatment, but they hadn't been treated less favourably than others. It was that. So particularly if there's discretionary parts of it, and you're not maybe you're doing something for an employee which isn't strictly covered by a policy or a contract. For example, if some companies will run a discretionary bonus scheme, or if you run a discretionary bonus scheme, make sure that you're treating all employees equally under that, and there's not some people getting preferential treatment. Sometimes that'll be warranted if it's performance based, but making sure again that performance criteria are clear, and they're well communicated, again helps with that, and just applying those things. I guess the final one is seeking advice when appropriate. I guess one of the, interesting parts of being an employment lawyer is that there's often situations which you've never seen before, and situations you could never have anticipated, and clients will come to us quite frequently with situations that we've never considered before. One of our biggest clients, they've got quite a substantial HR team, and they've come to me quite recently with quite a few different queries, which were situations which had never arisen before. How does this policy apply to this particular situation, because it's unique, it's not something we've dealt with before. So it's one of those where having the policies and sticking to them and dealing with them consistently helps, but often you will have situations which just haven't arisen before, and it's if you're unsure how a policy applies to that, it's seeking advice. I guess part of our job is to guide employers and deal in these situations so that you can avoid claims, or where claims are unavoidable, making sure that there's no chance that they've done anything wrong because they have taken advice and they've treated the employee fairly within the law. So yeah, that would kind of be one of those. It's the nature of the beast. Employing people, these things happen, disputes arise. It's something which employers have to deal with from time to time. So making sure that they have kind of follow these sort of steps, then helps to avoid any chances of any liability. And that's my contact details on that side there. So if there are any issues like this that people have, or questions, we'll do questions at the end of the presentation. But certainly, please feel free to get in touch with me.
That's absolutely super. Thanks so much, Andrew. I think this can set real great foundations for future growth, and just getting it right first time by getting the support and advice that you need is crucial. They do say, take time when hiring, be quick to fire. Sorry, I can't remember the words, but absolutely, get it right first time and that's the key message from here. Is there's a lot to consider, but there are people to help you with it, so don't feel alone. And that's great to put those details up there, Andrew. And I'm sure you'll have a couple of emails straight to you, no doubt. So let's open up the floor to questions. That I'm sure the entrepreneurs on this call will have some questions. Nima, straight in. Look at that.
Thank you so much. So my question is, if I, as a small business with 3 employees, if I hire someone for a specific project for a period of 2 years, and that project ends after 2 years, what would be the my responsibility in 2 years? After 2 years, can I just tell to the employee this project is there is no contract, there's no project, and we can't provide the job anymore?
Yeah, that's a great question. So it's perhaps something I didn't have time to cover, but I think in that aspect where you have a kind of a distinct piece of work, so if you've got a specific project and it is time sensitive, that's potentially where you would use a fixed term contract. Now with fixed term contracts, you always have to be careful with using them. I've had clients in the past where they just use fixed term contracts and just have fees for a period of time, and then they renew them and renew them and renew them, and that creates its own set of issues. I think if you have a distinct project which is for 2 years, and engaging someone on a 2-year contract for that project, but again, it come back to that about being clear and consistent in terms of the messaging of it, and it'd be making clear, and it'd be including drafting this within the contract that this is for a specific 2-year period and for this particular piece of work, so that when it comes to termination of that, then you can avoid some of the potential issues which may arise. So it's something which it's again having the end in mind, and making sure that things are appropriately documented at the start of the relationship means it's a lot easier when you come to the end of it, come to the end of the project.
Fantastic. Thank you so much.
Sharav.
Following up with Nima's question, so if we want them to be for a specific project and then we see that they have much more potential than that specific project and continue, should there be a clause, or how do we go forward with that?
Yeah, that's another good question. I mean, I guess in relation to that, if someone's been engaged on a fixed term contract, then often it will be that their employment will terminate upon the end of that fixed term contract. So whatever that period be, maybe 1 year, 2 year, or whatever's agreed. So if there's an employee which is working on a project and you're wanting to retain them, then I guess the strong suggestion would be that you would give them an updated contract to reflect the new relationship. And I guess this comes back to the point about constantly reviewing, and obviously I was talking about status there, but I guess in terms of just the contractual position, if you've engaged someone in a fixed term contract and the situation changes where you want them to be a permanent employee, then you would want to update the contractual documentation accordingly, just to make sure that, again, the new aspect of the relationship is documented clearly.
Thanks, Sheriff, and thanks, Andrew. Yeah, I've got a quick question as well, and probably pertinent to a lot of the earlier stage businesses. In terms of setting up your business from an employment legality point of view, if it's your own business, you have a shareholders agreement, you have a directors agreement. Should you also have an employment agreement, or does a directors agreement supersede an employment agreement?
So sorry, is that for individuals that you're engaging to be part of the company?
No, so that would be for us, for those who are running companies who have obligations through HMRC and the likes. Then should we have an employment contract? Well, I guess it's superseded by a director's contract, but I just wanted to make sure the hierarchy of what is needed, or is it determined by the status?
Yeah, it'll be driven by the status. So sometimes you'll have people where, and I've done this in conjunction with Joe's team before, where people are bringing on directors, and you'll often draft service agreements for those directors, and there'll be definite employment aspects part of that. So things which we would include as part of the employment contract will be included as part of the director's service agreement for those. So I guess with these sorts of things, it's making sure that you have, contractually, you have, whatever it is you're seeking to achieve, you have all that documented somewhere. So maybe you wouldn't necessarily have a separate document for it, but if there are, employment parts of it, that they are, included within the suite of documentation that you have.
Perfect. Thank you.
Just to add into that point, quite often what we see is a lot of it, because if you've got a company and you've got 3 founders who will be your shareholders and your directors, the critical point with the employment piece normally comes in depending on how much funding the company has got. Because in order to be an employee at its basic minimum level, you need to pay the minimum wage, and what's about £17,000 or £18,000 a year roughly, is it?
Yeah. I don't know what that'll work out salary wise, but the rates are due to go up again. I think it's £9.50 an hour. So that sounds about right.
Sorry, so you need to, as a basic minimum, pay the minimum wage, because otherwise you're not paying the minimum wage. Well, you could open yourself up for claims from HMRC, potential claims from an employee, you're in real trouble then. So normally the whole entire point with whether or not they're an actual employee depends on whether or not the company can actually afford to pay them. And then obviously it's to pay the NIC, pension, all the razzmatazz on top of that. So that's quite a critical point. What some companies do if they can't afford it, not quite often what we'll see, if they can't afford to be their non-employees, are doing effectively sweat equity, so they're not employed. Is at the point of investment, the investors will want them to be on proper employment contracts, which sets out all the rights and obligations of both parties. And at that point, it makes sense because the company's got investments, it's got the money.
Yeah.
The money to fund the payroll.
Is that what you see, Jay? So you might have somebody on a sweat equity basis, and they're not employed. They're essentially, it's an equitable relationship, and they're going to receive a reward for their work. Do you find that when you go through the process of investment, that the investors will then make sure that is then converted to an employment status?
Yeah, normally 99 times out of 100, what you'd see is at the point of investment, your sweat equity founders would switch to be employees. And normally what you've got is in your forecasts that the company's put together has got a payroll section.
Yeah.
To include that. And the reason for this would be is because your investors want the founders to be paid. Like everybody else. If there's only so long anyone can go in this world without receiving any monthly income. So at least if the founders, so there's an element of, okay, let's pay these founders as fair as we can just now. So at least they've got money coming in. Like, you can see how quite easily stress would get involved if somebody can't afford to pay their mortgage, but they're working really, really long hours, right? So henceforth, why ordinarily investors will want employment contracts put in place, which have got IP, confidentiality, restrictive covenants, all of that going in, but also it has metrics of somebody's actually getting paid for the work they're doing.
Yeah, that helps. Thank you. Are there any further questions at all?
The only other further thought I've got is, see, in relation to if you are thinking about going for basic and protecting company, at the start of it, when you're all founders, it's generally not the same people who are there at the start as they're at the end. So where we'll do quite a lot of work with Andrew and his colleagues in the employment team is exiting people out. So if somebody's employee, director and shareholder, that exit out piece and how to get rid of someone is critically important. And when Andrew was talking about the confidentiality and the restrictive covenants in the employment contract, they're really, really key at that point to protect the business going forward. So I think in terms of kind of to protect the company long term, our absolute advice would be to make sure you've got proper robust contracts which had all those terms in it in place, because unfortunately we see far too often that the founders are there at the start, not the ones there at the end.
Yeah. Again, a bit of a carrot to make sure that you're doing it all at the beginning and making sure we got the solid foundations to grow from. And I kind of come back to that whole, journeying out, forecasting, looking ahead to where you want to be and designing the foundations now that'll support that growth and that journey. And that incorporates, getting your legals right when it comes to employment. So, yeah, absolutely. Thank you. I think, bang on time there, but I think that's really useful. And please do take up the opportunity to ask any further questions that you might have of Andrew and the team. But just a big thank you so much from Entrepreneurial Spark and also the UK Space Agency for delivering this. Really, really useful. Thank you.